Article 31C, that the law gives effect to the policy of the state towards securing the principles specified in Article 39B, and C of the Constitution would not oust the jurisdiction of the court to go J into the question whether the law gives effect to the policy. The jurisdiction of Parliament or the state legislatures to incorporate the declaration in a law is conditioned upon the circumstance that the law is one few giving effect to the state policy towards securing the aforesaid principles, pp. 54, 855. If the 24th Amendment, which enables Parliament to make an amendment of the fundamental rights in such a way as to take away or abridge them, is valid, what is there to prevent Parliament from enacting a constitutional amendment making it possible for Parliament or state legislatures to pass laws for implementing the directive principles specified in Article 39B and 39C, which would be immune from attack on the ground that those laws violate Articles 14, 19, and 31(9). Article 31C is a proviso to Article 13(2), in that it enables Parliament or state legislatures to pass laws of a particular type which would not be deemed to be void, even if they violate the provisions of Articles L4, 19, and 31. Article 31C merely carves out a legislative field with reference to a particular type of law and exempts that law from the ambit of Article 13(2) in some respects, merely because a law passed by the Parliament or the state legislatures to give effect to the policy of the state towards securing the directive principles specified in Article 39B and C in pursuance to valid legislative entries in the appropriate lists might violate the fundamental rights under Article 14, 19, and 31, and such a law is deemed not void by virtue of Article 31C. It would not follow that Article 31C has invested Parliament in its legislative capacity, or the state legislatures with power to amend the Constitution. It is not for the court to prescribe for the society, or deny the right of experimentation to it within very wide limits. P. 854, 855. A law which will never give effect to the state policy towards securing the principles in Article 39B and Article 39C will enjoy no immunity if any of its provisions violates these articles. The legislative jurisdiction to incorporate a declaration that the law gives effect to the policy of the state is conditioned upon the circumstance that the law gives effect to the policy of the state towards securing the directive principles specified in Article 39B and C. The declaration can never oust the jurisdiction of the court to see whether the law is for giving effect to such a policy, as the jurisdiction of the legislature to incorporate the declaration is founded on the law being one to give effect to the policy of the state towards securing these principles, in order K decide whether a law gives effect to the policy of the state towards securing the directive principles specified in Articles 39B, or C, a compt will haw to examine the pith and substance, the true nature and character of the law, as also its design, and the subject matter dealt with by it together, with its object and scope. Tip 5, 856. Beg, concurring with Ray. Palikar, Matthew, and Dwivedi 2. The Constitution. 24th, 25th, and 29th Amendments are valid. P. 85, 886. We should approach the questions placed before us from the pragmatic angle of the changing NC/DS of social and economic orders visualized by those who were or are the final judges of those needs in exercise of the constituent power. Kesavananda Bharati, Beg, J. 67. It is clear from the preamble as well as the provisions of Part 3 and of 4 of our Constitution that it seeks to express the principle salute populi suprema lex. In other words, the good of the mass of citizens of our country is Lilac supreme law, embodied in our Constitution, the voice of the people, king through the Constituent Assembly, constituted a new republic which was both sovereign and democratic. It sought to secure the noble objectives laid down in the preamble, primarily through both the fundamental rights found in Part 7 and the directive principles of state policy, found in Part 4 of the Constitution. It would not be correct to characterize the fundamental rights $3, merely the means and the directive principles as the ends of the endeavors of the people, from the point of view of the preamble. Both fundamental rights and directive principles are means of attaining the objectives which were meant to be served, both by the fundamental rights and directive principles. Perhaps the best way of describing the relationship between the two would be to look upon the directive principles as laying down the path of the country's progress towards the objectives stated in the preamble, with fundamental rights as limit of that path, like the banks of a flowing river which could be amended or mended by displacements.